Thank you. Honorable Minister of Finance, I notice he's absent. Is anyone deputized this podium?
Madam Speaker, the Honorable Minister of Finance is absent from today's session. Has asked me to present on his behalf to the National Assembly the annual report of Guyana Power and Light, Inc., for the year ending 31st of December 2011. Also, Madam Speaker, any other business in the name of the Honorable Finance Minister will be dealt with tonight.
Thank you, Honorable Minister. Mr. Clerk.
Reports from committees. Oral questions without notice. Questions or notice. Statements by ministers, including policy statements.
I've been advised by the clerk that the Honorable Minister of Housing, Minister Irfan Ali. I understand there's a statement from you. Please proceed.
Thank you very much. Anil, Madam Speaker, we have sent a request for adjournment to raise a matter on the public voting.
That is not yet on the agenda. We're going through the agenda as it's fixed. And we're now at the heading which speaks of statements by ministers, including policy statements.
The statement was by Attorney General, the Honorable Attorney
Oh,
General.
well, this is my information.
Okay.
Okay. Honorable Minister, please proceed.
Thank you very much, Madam Speaker. And even before I begin, my honorable colleague across Honorable Speaker and honorable members of the House, on the 22nd of April 2013, the Anti-Money Laundering and Countering the Financing of Terrorism Bill, Amendment Bill of number 2012 of 2013, was laid by me and read for the first time in this honorable House. This was during that hectic period when this honorable House was considering the national estimates and expenditure for the year 2013. The bill was read a second time on the 7th day of May 2013, some 2 weeks thereafter. On that occasion, I articulated the importance of the bill, the significance of its timely passage, and the likely regime of consequences which will ensue if the bill is not passed. Despite our best efforts and appeals, the opposition, using their votes on the floor, voted for the bill to be sent to a special select committee. I argued against this option, pointing out then that though it is desirable in most cases for us to do so, this situation simply does not permit that to take place. Again, my exhortations were in vain. At or about midnight on the 7th day of May, the Honorable Speaker of the National Assembly convened a meeting of the Committee of Selection and constituted that Special Select Committee. The Special Select Committee held 4 meetings on May the 8th, May the 13th, May the 16th, and May the 20th. At the first meeting, the modalities of how the committee will conduct its business were worked out. At this meeting, the opposition members of the committee insisted that a notice be placed in all the daily newspapers, inviting members of the public to submit their contributions in writing. The government members agreed. The opposition members further requested that specific agencies be written to, inviting them to make submissions. These included the Bank of Guyana, the Director of Public Prosecutions, and several other agencies. Again, the government agreed. The opposition members next requested a list of all documents of the CFATF recommendations, reports, and correspondence with Guyana on this matter. Again, the government members agreed. The opposition members next requested the names of the experts that the government will have in the committee to assist the committee in its work. Again, the government agreed to supply those names. The government made a singular request, and that is that having regard to the urgency which attaches to this bill, that the committee sit daily so that it can complete its work within the time prescribed, and so that the bill can be read a third time and passed at this sitting of the House. This singular request of the government was rejected and the meeting was adjourned. Before the second meeting, the government complied with all the aforementioned requests which the opposition made. In the meanwhile, the Private Sector Commission, the Georgetown Chamber of Commerce, and the Quarantine Chamber of Commerce all issued public statements calling upon the National Assembly to pass the amendment and expressed apprehensions regarding the impact upon our nation and commerce in particular if these amendments were not enacted on or before the 27th of May. His Excellency the President and several members of the government issued similar calls and expressed like sentiments. At the third meeting, work begun on the bill at the Select Committee, and indeed work progressed well. Several clauses of the bill were examined and certain changes duly made. At the end of that meeting, the government again reiterated its position that the committee should meet daily until its work is concluded. Again, this suggestion was rejected and the meeting was adjourned to the 20th of May upon the opposition's request. On the 20th of May, after the meeting was called to order, Your Honor indicated, as a member of the committee, that the leader of the opposition, the honorable leader of the opposition, had written to His Excellency the President that very day to explain that the honorable President, that His Excellency the President had indeed dispatched a response to the leader of the opposition that very day, but the APNU members were disinterested. The President's response was later read into the minutes of the meeting. Mr. Ramjatan from the Alliance for Change, Mr. Kemal Ramjatan, the honorable member, Alliance for Change, entered the meeting for the first time at that stage and indicated that he came to pick up his documents. He also left. The meeting was thereafter terminated for want of a quorum. The effect is that Guyana will be unable to effect the recommendations made by the CFATF before the CFATF's plenary, which will take place on the 26th and 30th of May 2013 in Nicaragua, at which forum Guyana will be evaluated to determine its compliance with certain key and core recommendations made by the CFATF. It has been argued that this bill and Guyana's obligation came as a surprise to many, but this is an inaccuracy. This monitoring process is an ongoing exercise, and Guyana has been submitting reports at the requisite periodic intervals. These reports are all published on the CFATF website. The recommendations which were made were done so over a period of time, and all the recommendations did not come at once. Indeed, over 90% of those recommendations consisted of minor legislative changes, and it was agreed that those changes will be chronicled in a singular compendium which will be presented to this House in a singular amendment, and that is the bill which was presented. In addition, pursuant to earlier recommendations, Guyana expanded its money laundering and countering the financing of terrorism regime since July 2011 by appointing supervisory authorities for the following entities: 1. Casino; 2. Cooperative and credit unions; 3. Friendly societies; 4. Dealers in precious metals; 5. Dealers in precious stones; 6. Money transfer agencies; 7. Insurance companies; 8. Financial leasing businesses; and 9. Trust companies. Also, all financial institutions, cambios and money transfer agencies have been filing reports as required by CFATF standards. It has also been contended publicly that the sanctions which may flow from Guyana's failure to comply with the CFATF recommendations are unknown. Well, in life, most things are unknown to those who fail to acquaint themselves with the relevant facts. However, a little research would unearth that if this eventuality occurs, Guyana would be placed on a list of jurisdictions deemed as non-cooperating and insufficiently compliant with FATF recommendations, and member states will be called upon to apply countermeasures when dealing with that jurisdiction. Additionally, non-cooperating members will be placed under FATF administration and will have to report semi-annually in Paris, France, at considerable cost to the country. Trinidad and Tobago just came out of FATF review. They were not fully deemed non-cooperative. However, they passed the necessary legislation similar to the bill. I read the debates in the House, and speaker after speaker on both sides of the House emphasized the importance of rectifying Trinidad's status, and they all recited a litany of instances and examples of the types of businesses which were affected by Trinidad's impugned status. They range from transactions with international financial institutions to the purchase by private citizens of the most minuscule item on the internet. Indeed, all forms of transactions which involve the payment or receipt of money in and out of Trinidad and Tobago were affected. So important was this piece of legislation that it received the unanimous support of the Parliament except one dissenting voice. It is manifest that national interest and patriotic sentiments overwhelmed and subsumed political considerations. The people of Trinidad and Tobago won in the end. Sadly, the reverse obtains in Guyana. Thank you.
Thank you very much, Mr. Clerk.
Personal explanations. Request for leave to move the adjournment of the National Assembly on definite matters of urgent public importance.
Thank you. Honorable members, this afternoon, just prior to the sitting, I received a letter addressed to the Honorable Speaker, Mr. Trotman, but for my attention, in my capacity, the acting Speaker for today's sitting. It's very short and I will read it. Dear Madam Speaker, and it's signed by the Honorable Prime Minister Samuel A. Hines, Prime Minister, Leader of the House. Dear Madam Speaker, the government is seeking leave to move the adjournment of the National Assembly on a definite matter of urgent public interest at the sitting of May 22nd, 2013, in keeping with Standing Order 20. The government wishes to advise the National Assembly on the status of Guyana's report to the May 2013 Caribbean Financial Action Task Force International Cooperation Review Group Plenary in Managua, Nicaragua, and the status of the Anti-Money Laundering and Countering the Financing of Terrorism Amendment Bill 2013, number 12 of 2013. This matter, in our opinion, is one that satisfies the definition of definite, urgent, and public importance, as can be assessed by the level of public concern this matter has generated from a wide range of national stakeholders, most significantly civil society organizations. Sincerely yours, Samuel A. Hines, OE, MP, Prime Minister, Leader of the House. It was copied to the Leader of the Opposition and to the Clerk of the National Assembly. Honorable members, I have looked at Standing Order 12, which is the standing order that the Honorable Prime Minister is seeking to invoke. I have looked at the ruling of former Speaker, the Honorable Harry N. Ramkaran, SCMP, dated the 15th of March, 2004. And I am of the view, and it is my ruling, that the matter contained in the letter addressed to me by the Honorable Prime Minister does not meet the requirements of Standing Order 12. Standing Order 12 speaks about definite. We can perhaps say that, we can say that it is definite. It speaks about urgent. And in his ruling that I averted to just now, the ruling of the Honorable Harry N. Rampuran, SCMP, dated the 15th of March, he speaks about urgent being suddenly in the matter of an emergency and should not have arisen over a series of weeks. In my view, this bill, it did not arise, and particularly in keeping with the Honorable Harry N. Rampuran ruling of the 15th of March, which I am, of course, willing to, and in fact I would want to suggest to the clerk that it is photocopied and circulated. I rule that the matter does not qualify as a definite matter of urgent public importance. Before we move on, Honorable Minister of Legal Affairs, Honorable Minister Nandland, could I indicate to you, sir, I'm sure, I know you will be aware of it, and I'm reading now from the Handbook for Members of the National Assembly dated 2008, and it says on page 56, copies of ministerial statements made in the National Assembly should be circulated to members of the Assembly. A minister must therefore ensure that copies of the statement made by him, I would presume, or her, are produced and made available to the clerk for distribution at the same sitting at which the statement is made. I did notice, Honorable Minister, that you were reading from what seemed not to be a typed document. I would be grateful if you could indicate to the clerk, through me, when you will be in a position to make your statement available so that it can be circulated. I'm not saying today, but could you indicate?
I'm trying to follow the. You want to speak on my behalf, Mr. Nagamoto?
Don't let Mr. Nagamoto distract.
I will try my best, Your Honor, to abide by the stipulation of that time. I'll have it ready before the end of today's.
But if not today,
If not the earliest, tomorrow.
thank you very much. Sorry, Honorable Minister.
Yeah, Madam Speaker, with full and complete respect for your ruling, I am asking if you will allow, as in other cases where similar ruling were made, you will allow me to make a few comments on the issue of that.
No, I will not. Honorable Mr. Clerk, please proceed.
Motions relating to the business or sittings of the National Assembly and moved by Minister. Introduction of bills, public business, government's business.
Honorable members, we will now proceed with the second reading of the Customs Amendment Bill 2013, Bill number 2 of 2013, published on the 8th of January 2013. Honorable Minister, sorry.
Minister of Farmer, Minister.
Honorable Member, Mr. Greenwich.
Madam Speaker, if it pleases you, I would like to urge the minister that this bill, given that there is a certain sympathy, there have been some discussion on it before, and a certain understanding that we needed to arrive at a certain point prior to its readiness for presentation to this House. I'd like to recommend to the minister that the matter be deferred for consideration at a later date.
Honorable Minister.
Madam Speaker, I rise to move that the Custom Amendment Bill 2013, Bill number 2 of 2013, published on the 8th of January 2013, be read for a second time. Madam Speaker, while I heard the Honorable Member, Mr. Carl Greenidge, asking for a deferral, may I indicate to you, Madam Speaker, and this Honorable House, that it was the opposition that asked that this bill be deferred since January for consultation, and up until today's sitting, when I was approached again by the Honorable Member who spoke before me for a deferral, no substantive objection to this bill was made. Madam Speaker, I don't believe that this is a matter that should attract any significant controversy, or I don't believe it's a matter that is set in any difficult circumstance. And I would propose to highlight why this Honorable House should support this legislation, and we should have a unanimous vote of yes to support this. In February 1995, Guyana introduced an environmental tax on imported beverages in specified containers. The environmental tax legislation, which was Bill No. 4 of 1995, dated February 15, 1995, was enacted through an amendment of Section 7 of the Customs Act in 1995. The new Section 7A of the Customs Act stipulates that an environmental tax shall be raised, levied, and collected at a rate of $10 on every unit of non-returnable metal, plastic, glass, or cardboard container of any alcoholic or non-alcoholic beverage imported into Guyana. And every import of such beverage shall pay such tax to the control of customs and excise at the same time when custom duties are paid. Madam Speaker, the objective of this tax was based on the grounds of environmental protection. And I believe all the honorable members of this House are aware that in Guyana we have a difficulty as it relates to plastic. I think here in Georgetown we see the brunt of it, and sadly, as I travel around the country, I'm seeing the effects of this in other regions as well. Non-returnable containers in which beverages are imported have been deemed to pose a negative impact on Guyana's environment, primarily as a result of their non-biodegradable nature. And like I indicated, we have the pileup and the attendant higher waste management costs for public authorities. It was deemed as reasonable to expect that a cleanup cost should be borne by the businesses concerned. The issue, however, here, Madam Speaker, is that the environmental tax, as currently applied by Guyana, has been determined by the Council for Trade and Economic Development of CARICOM to be discriminatory on the grounds that it applied on imports only and not on domestically produced goods. This amendment that we are proposing, Madam Speaker, is to bring us in line and to cause us to honor our treaty obligations. It is as simple as that. The amendment is seeking to amend the first schedule of the Customs Act by the deletion of Section 7A and to implement the new legislation for the administration of the environmental tax. It is intended to bring Guyana into compliance with its obligations under the Treaty of Chaguaramas and the World Trade Organization Convention, both of which Guyana is a party. The current provision imposes environmental taxes solely on non-disposable containers of imported alcoholic beverage. This is not only discriminatory, but it's in breach of Guyana's obligation under the treaty and the convention aforementioned, exposing Guyana to the risk of litigation and sanctions under the originating jurisdiction of the Caribbean Court of Justice, notwithstanding unfair trade practices. I'm sure that my colleague, the Honorable Attorney General, when he speaks to this matter, will highlight that actually there is active legislation as it relates to this matter, of which Guyana is involved. This amendment, Madam Speaker, seeks to apply a tax on every unit of non-returnable containers of alcoholic beverages on both imported and goods manufactured in Guyana. Both what is imported and what is manufactured in Guyana. We are proposing as well, through this piece of legislation, to reduce the rate of the tax from $10 to $5 in an effort to allow the tax to remain revenue neutral. And we are also seeking to remove the applicability of the taxes when the goods aforementioned are exported and not used in Guyana. This provision, Madam Speaker, while it imposes an additional tax of $5 on domestic manufacturers of alcoholic beverages, will encourage the said manufacturers to retrieve and re-export the said goods, since when such goods are exported, the tax no longer becomes applicable. This is anticipated to have two benefits. One, upon the re-export of the said containers, to refund a tax may be paid to the domestic manufacturer, resulting in no increase in the cost of locally produced beverages. And secondly, attempts to retrieve and re-export the said items will have significant environmental benefits and result in job creation. Madam Speaker, while it is true that we have companies in Guyana that may have concerns about this particular amendment, consultations were held and time was asked for consultation, but the bottom line is that we cannot continue to delay. As a matter of fact, another country in the CARICOM was deemed to be non-compliant, and they have since taken the steps to bring themselves in line. And I'm sure that some of the other speakers to this amendment will highlight this. Like I said before, I believe this is a matter that should attract support of all members of the House, since it only brings benefits to the peoples of Guyana. And I'm sure with proper understanding and a proper review coming out of today's debate, this amendment will attract the full support of all members of the House. I thank you, ma'am.
Thank you very much, Honorable Minister. I now invite Mr. Honorable Member Mr. Greenwich to make his contribution.
Thank you very much, Madam Speaker. Madam Speaker, I think it is somewhat unfortunate that the Minister didn't take the opportunity to defer the bill before us. The story that he related about the history of this bill is worthy of some attention. Let me say first of all, whilst it is clearly true that it was a member of the opposition that sought the approval of the House to defer consideration of this bill on the last occasion. Let me just remind the Minister, or maybe I'm telling you for the first time he didn't know, that request on the part of the opposition was done at the request of the Minister of Finance, okay? And it arose because the Minister of Finance had not concluded his deliberations with the private sector. That is an obligation that he had, and he failed to do it. So don't let us be told that we have an obligation to implement or to agree to a second reading at this stage simply because in the past we had asked for it before. We did not ask for it by virtue of wanting something ourselves. We are facilitating the government because at that time, as now, hanging over the heads of the government was court action. The court action arising from the lawlessness that this government has always characterized the manner in which this government operates. The minister gave us a story, sounded very good, of legislation which needs to be passed in order to satisfy CARICOM requirements. There is no legislation in CARICOM. We have no obligation in CARICOM to implement this so-called environmental tax. Okay? It is not an environmental tax, first of all, and secondly, there is no obligation to implement it in the manner that the minister suggests. The CARICOM became involved in this exercise because in implementing customs legislation, the government discriminated against foreigners who were exporting to Guyana. That is the source of the problem. Shut up. The legislation is, Madam Speaker.
Mr. Granger, Mr. Granger, sorry.
Yes, madam. I withdraw.
Yes, thank you. I was going to ask you to withdraw that. Thank you very much.
The legislation, there are a range of mechanisms. I have them here, but I'm not sure that it's appropriate to detain the House at this stage, and because we can do it when the minister, if the minister seeks to bring the bill at another time and doesn't take these into account. What I'm saying at this stage, that this is not an environmental tax, it is an abuse of the term, and the question of its urgency, is one that I think it's subject to interpretation. I don't deny that there's a court case at the CCJ, and the government will have to address that matter. If it loses the case, it will lose money. But the problem that gave rise to that does not reside here in the House. The legislation that caused the government to be subject to such action is caused by the government insistence on passing legislation which does not conform to its international obligations and more specifically to its treaty obligations with the CARICOM under the Chaguaramas Treaty. And the court case, which carries the threat of financial sanctions, of course, is something that we should try and avoid. But there still remains the need for the government to conclude its discussions with the other parties, and also for them to ensure that we are satisfied so that the legislation can go through without fear of opposition. Madam Speaker, the key word I've been hearing all afternoon seems to turn on patriotism, in which suddenly the opposition is being called on to be patriotic and to pass this legislation or this type of legislation without a murmur, just to show that they are patriotic and have the interest of the country at heart. I think a more reasonable requirement would be for the government to consult before bringing the legislation so that we have no difficulty in supporting the proposals that they bring before the House. I'm tempted, Madam Speaker, to recite Samuel Johnson's aphorism in which he refers to the tendency of certain elements to have resort to patriotism. You know the expression, Anil? Patriotism is the last refuge of a scoundrel. That is the story that faces us today. You have a serious matter before us, and instead of trying to resolve it in a manner that is constructive and expeditious, we are being offered a recipe with one option. You either support what the government wants in the time that it sets, or you deem to be unpatriotic. Madam Speaker, we cannot support the bill at this point in time. Let the minister bring it back in due course. Thank you very much.
Honorable Member Minister Karen Rees-Burkett.
Thank you, Madam Speaker. I rise to speak in support of the Customs Amendment Bill before us. Madam Speaker, this bill will bring us into compliance with a number of our obligations, regional and international. To say that there is no obligation on the part of Guyana as it relates to this particular tax and its application, it's not the truth. Let me read, Madam Speaker, from the revised Treaty of Chaguaramas, which came into force in December 2005. Bear in mind, the environmental tax was included in the Customs Act of 1995. That revised treaty was passed in this National Assembly through Act number 8 of 2006. And this is what it says in Article 90, which deals with internal taxes and other fiscal charges. I quote, "Save as otherwise provided in this treaty, member states shall not, A, apply directly or indirectly to imported goods of community origin any fiscal charges in excess of those applied directly or indirectly to like domestic goods, or otherwise apply such charges so as to protect like domestic goods." So there is an obligation on the part of Guyana to not discriminate. So it is not true to say we don't have an obligation to carry on. Madam Speaker, the Honorable Minister Edgell outlined clearly what is the problem we are trying to fix. Basically, we are trying here today, we're bringing this bill to this amendment to make this tax non-discriminatory. Madam Speaker, Mr. Gray spoke about the name of the tax, and I'm sure that we can argue about the name. This tax was there since, like I said, 1995. But I'm sure that there are ways that we can look at how we expend the resources obtained from this tax. Madam Speaker, this has been the subject of all of the COTED, which is the Council of Trade and Economic Development meetings that I have attended in the last 5 years or so. And In 2005, what the CARICOM Secretariat did was to look at this very tax that was being implemented in 9 member states. And they found, and I said this very tax that was implemented in 9 member states, and what they found that 6 member states, including Guyana, were applying the tax on a discriminatory basis. Since that study in 2005, Madam Speaker, member states sought to address the matter. And at the Heads of Government meeting last year, in July 2012 in St. Lucia, this matter became so urgent and so important that it was elevated from the COTED to the Community Council to the Heads of Government, because 2 countries were still not compliant, and that's Guyana and St. Lucia. Madam Speaker, both of our countries then, at that meeting, committed that we are going to address this issue. In October last year, 2012, St. Lucia addressed the matter, and so that leaves Guyana. If this amendment is successful today, one has to be optimistic, then all of our countries in CARICOM will be compliant as it relates to this particular matter of an environmental tax. Madam Speaker, as we continue to promote Guyana as a destination for investment and a country that adheres to regional and international obligations, it is my humble submission that we cannot delay the passage of this very important amendment. Indeed, Madam Speaker, you will recall when I came to this House with the amendment to the Caribbean Community Free Entry of Skilled Nationals Act in July 2011, I had informed this August House that CARICOM did an appraisal of all of our member states as it relates to our obligations under the single market. Guyana led CARICOM in terms of meeting our obligations. We were deemed substantially compliant. There were a few issues, and on top of that list was the addressing the environmental tax. So if we are able to address this matter today, we would certainly be in the 90th percentile of adhering to our obligations under the CARICOM single market. Madam Speaker, apart from our regional obligations under the revised Treaty of Chaguaramas, you would recall that we signed the Economic Partnership Agreement in 2008, and I came to this National Assembly in May 2012, and the House unanimously approved the ratification of the Economic Partnership Agreement. Madam Speaker, under Article 27, dealing with national treatment on internal taxation and regulation, this is what is stated in the EPA, and I quote, "Originating imports shall not be subject either directly or indirectly to internal taxes or other internal charges of any kind in excess of those applied directly or indirectly to like domestic products. Moreover, the parties and the signatory CARIFORUM states shall not otherwise apply internal taxes or other internal charges so as to afford protection to like domestic products," end of quote. Even though, Madam Speaker, I recognize that the importation of beverages from Europe is not significant, just around 2% or so, the passage of this legislation will nevertheless bring us into compliance with our obligations under the EPA as far as it relates to how we apply the tax. It is my view that it's only a matter of time as imports increase from Europe that this will also become an issue. Madam Speaker, the Honorable Member, Bishop Edgell, spoke about our obligations under the World Trade Organization. Let me say, Madam Speaker, that when we appeared before the WTO for the trade policy review in 2009, member states of the WTO raised this issue of the environmental tax and asked that we address it, bring it in line so that it will be non-discriminatory. And at that time, we committed to review the tax as well. So in other words, Madam Speaker, we're looking at our regional obligations under the revised Treaty of Chaguaramas. We're looking at our obligations under the EPA. We're looking at our obligations at the WTO as well. Let me say, Madam Speaker, for what it's worth, that the bulk of the beverage imports in 2011 came from Trinidad, about 55% or so. Suriname came second with 22.5%, and the United States of America with 9%. I should also note that in 2009, importation from CARICOM member states accounted for about 89%, but that was reduced in 2011 to about 83%. We have seen some new exporter countries, if I could say that, added to the list over the last 2 years. We now have beverages coming in from Turkey, Panama, Mexico, Vietnam, Denmark, Poland, the UAE, and Singapore. In the last 2 years, we have seen these new exporting countries added to our list. And so I can only imagine that as our country develops, so does our liquid appetite as well. Madam Speaker, it will be disingenuous on my part if I pretend to be unaware of the concerns of our local manufacturers and producers on this matter. I am aware of their concerns specifically as it relates to the unfair, quote-unquote, unfair competition from other member states, where cost of production is much lower than Guyana because, Madam Speaker, there is an abundance of a specific input needed in the production process. Madam Speaker, this matter, I am sure, would have been elucidated and debated in all of the member states that had the same concern as we have in Guyana with respect to competition. There is a view, Madam Speaker, that even after transportation costs and other costs are factored in, that these beverages can still be sold cheaper than what we produce here locally. Madam Speaker, we are also well aware of the many voices across the Caribbean Sea speaking about the issue. We feel, utopian as that might sound, will be undermined. With the advent of the Caribbean Court of Justice, Madam Speaker, the wiggle room, so to speak, has become much, much smaller, if existent at all, in some cases. Member states are being taken to court. Guyana, along with the CARICOM Secretariat, was taken to the CCJ on the issue of cement, and now on the environmental tax. Suriname was taken to the CCJ on the application of the CET on flour, or non-application of the CET on flour from extra-regional sources. Barbados has been taken to the CCJ with respect to the alleged maltreatment of a national of that country. And so, Madam Speaker, this is where we are today in 2013. We therefore have to adhere to our obligations as far as possible in keeping with our reputation too as a trusted partner in the regional and international community. We are seen as a country ripe for investment with sound macroeconomic fundamentals as evidenced in our consistent growth. This amendment today is just another step in the right direction as we promote our country as a destination for foreign investment and joint ventures, while at the same time strengthening our relations with CARICOM neighbors. Madam Speaker, as I close, let me say this. At the last quartet, there was a discussion even, and I can say this here, amongst member states, whether the community can take Guyana to court on this matter. And so it's a very, very serious issue, and I would really like if we can approve this amendment today, and some of the concerns that Mr. Grillage voiced, I'm sure we can find a way of further. We did have engagements with the private sector. Indeed, the individual who was slated to look at doing some work for them, as you know, Mr. Grillage is now part of the government of Grenada, and so we're doubtful that anything can come out of that in the near future. I would like to, I was told earlier that APNU had indicated that they will oppose this bill, and I hear now we speak about a deferral. But I believe that we can pass this amendment and we can find ways of putting some of the measures in place with the private sector here to cushion the effects. I ask for your support. I thank you.
Thank you very much, Honorable Minister. I now invite Honorable Member Mr. Ramjitan to make his contribution.
Thank you very much, Madam Speaker. This bill that is before us shows the holistic approach that ought to be taken by the government and the repercussions of not having it passed ought to also be understood by them. And in that context then, when a request is made for a deferral and they're pushing ahead the bill, deferral to whatever date it will be. But the trouble is, and this is what brings me to the point, they do not appreciate, Madam Speaker, the necessity for consulting, the necessity for us understanding all the issues, and now they come pleading with us. Please, it has implications for the treaty rights and obligations under the CARICOM regime. And they also come pleading with us that indeed we do have litigation at the CCJ level that might very well jeopardize this country. I want to let this Parliament know, Madam Speaker, that we appreciate those arguments. We also in the Alliance for Change want to say that a tax is a tax is a tax. And that is what is going to happen here. This government only wants to tax. It taxes the environmental, this bill here, in connection of extracting from every bottle or whatever it is, package that comes into this country, a $10 tax. When now there are implications in relation to this tax, because of course other persons in Suriname and Trinidad having to pay this tariff for allowing their goods to enter into Guyana, it has an implication. What this government now wants to fast track is that we're now going to put a jeopardy, we're going to put in jeopardy our manufacturers by stating that, look, instead of the $10, we are now going to charge the people from outside $5, and our manufacturers going to have to pay the other $5. That is not how I view an investment climate, Madam Speaker. I view it that if there is a certain percentage that we need for the environment, let's drop it to that and it will be across the board. It has to be low enough to also make accommodations for our businessmen. I spoke to a number of the businessmen. They are not in support of this bill. They are not, none of them are in support of this bill. They are saying it is an additional tax. And this government will come and say nothing about the sentiment of what the businessmen feel about this bill. But they can go and say how the government, how the private sector feel about the anti-money laundering bill. And they're going to play that over and over in NCN. They're not saying that this bill, none of the businessmen that manufacture with these bottles and plastics and so on, they're against it. You know that? And so that is how they discriminate. And they come now and say, well, we have to be discriminatory and do a couple of things that will make them still get that set of money. That is, it's going to be revenue neutral. I want to ask a question, and I notice it here. Government details of revenue estimates. Page 7 of volume 1 of the estimates that we so thoroughly went through last couple of weeks. An environmental tax, this government collects $1.1 billion almost every year. when we see what is happening in Georgetown, and all that garbage, and all that, what is called environmental hazards, a little rainfall the other day, the whole city stinks. We have to start thinking holistically as to what it is that we're doing with this tax that we're collecting. That is also an important question. And the businessmen that we spoke to, private sector commission in the Chamber of Commerce, even other places privately at cocktails, where is that money going to, Mr. Ramjatan? And I have to say that I don't know really where it is going. But the trouble is, we have that kind of quality argument now coming. Oh, we are going to breach our obligations if we don't get this National Assembly to pass it. Well, this National Assembly, like in so many other things, want explanations before it's going to pass. And that is why we ask for a forum. No, but let's go ahead with it, and we're going to talk about it after. You think we're going to talk after, knowing how they behave? They're not going to talk to us. They're going to laugh and say, well, it passed, and the president will accept it, and then it becomes. And they will go to the CCJ and say, well, whatever it is. I want us to understand that this side of the House, the Alliance for Change side here, will not be pressured by those arguments at all. Bring the entirety of the issue to the public of Guyana. Let the ordinary King Cutter know what this bill means to them. And let me tell you what it means. When they put that $5 per bottle on the Guyana's manufacturer, you know what the businessmen then told me that are going to matter is the consumer will have to pay more. But they don't want to tell them that is an implication. No, they don't want to say that. The manufacturing all indicated to me that this is what will be the implication because they don't like to take losses. So this $5 a bottle will go down to the consumer. Consumers will have to pay more. Every little school child that wants a little beverage or whatever for their nutrition and whatever, more they got to pay now. But the implication is not on the NCN. They got talking all kinds of other issues that are not important. And then they come here and they will say the AFC yet again block another beautiful piece of legislation. The Alliance for Change, madam, in the context of what has happened and the fact that we have consulted the stakeholders here, cannot support this. We do not feel too that this urgency of the argument, our CCJ and commitments have been made with the cogency and the conviction that we think that it ought to be to change our mind. And to that extent then, this is not going to get the support because, as I said, a tax is a tax, and that is what this government loves. Tax its people, or indirectly cause them to suffer from higher prices as a result of taxation. And for the sake of the people out there, we are not going to in any way support it, the consumers and the manufacturing class. Thank you very much.
Honorable Attorney General.
Thank you very much. Madam, I was not scheduled to speak, but having listened to Mr. Ramjatan, I feel compelled to respond. Madam Speaker, is the competing claims have always been that if it is that you are going to enter into treaty, it is a sacrifice of your sovereignty. Every treaty that you enter into, you lose a degree of your independence as a sovereign nation. That is a fundamental truth and a legal fact of international law. Mr. Ramjatan must be aware, and I'm not sure what I'll tell you, that Guyana has been a signatory to the Treaty of Chaguaramas from the inception. In fact, Guyana is a founding member of that treaty. There is no doubt that an obligation devolves upon Guyana to carry out the terms of that treaty. And those obligations include the passage of a legislation of this type. Guyana does not have a choice.
Attorney General, I think Mr. Benedict.
pointed out before that the legislation to which the minister made reference and the attorney general is making reference says absolutely nothing about an environmental tax. It is a point of order. You're misleading us. It says nothing about an environmental tax. The legislation discriminates against CARICOM exporters. And that is what the Chaguaramas Treaty and its subsequent amendment address. The government cannot come here to tell us, they should not come here to tell us that the legislation to which he is making reference says anything about this tax before us. It says nothing about the environmental tax. Thank you, Madam Speaker. So let me draw.
Honorable Minister.
I did not use the term environmental tax. I am saying that the tax which is here, which is contained in the measure in this amendment, is part of our obligation under the Treaty of Chaguaramas. It was.
It is the rates.
Please allow the honorable.
Madam Speaker.
Honorable Attorney General. Members. Honorable Attorney General, address your comments to me. Honorable Attorney General to make his presentation. I do see that there's someone else listed from the opposition to speak subsequent. And if there is a divergent view, I'm sure that that member will adequately. Your point of order be noted, Mr. Greenwich. Honorable Attorney General, please
Thank you very much
proceed.
for your protection. Your Honor, I don't understand why. I didn't concede that there's going to be a dispute as to whether Guyana has an obligation to impose this measure. It is beyond dispute. Every country in the Caribbean has done so. The last to do so was St. Lucia. If the records are checked, you will see Guyana having this as an outstanding item on the quoted agenda for the last 6 or 7 years. And every time we go, we have been able to get a deferral. For the same reason articulated by Mr. Ramjatan, because we recognize that it will cause some hardship on local manufacturers. We are not unmindful of the ramifications that it will have on our commercial sector. We are also very acquainted with the disparity which exists in the cost of manufacturing and production in Guyana as opposed to Trinidad, for example, principally because of the different rate or cost of electricity. It's not a magic. And because for that reason, we have deferred this bill at every occasion that we were compelled to do so, until we simply ran out of excuses. The truth of the matter is that with the advent of the Caribbean Court of Justice, CARICOM Treaty now has a forum to which they can go to enforce. Prior to that, countries had no way or no effective way of imposing the obligations which flow from the Treaty of Chaguaramas. And one of the principal reasons why that court was established was to confer upon that court a treaty jurisdiction to enforce all treaties and obligations which arise under SME and CARICOM, etc., at that court. And as a result of that, my friend used a very articulate terminology, the wriggling room. The wiggle room quickly evaporated. And we had a series of litigation commenced in the Caribbean. We had the TCL matter, we had the Hummingbird case from Suriname, brought by Trinidad, and now we have this matter brought by Rhodesia, the beverage company, from Suriname. So, Your Honor, while I hear my learned friend, Mr. Ramjitan. And I agree that this is going to have an adverse consequence on local manufacturers. We know that, that's not a secret. We have been negotiating with the local manufacturers for a very long time. And that is why the original thing was $10 and we have reduced it to $5. That came as a result of a request from the private sector, as a result of our consultations with the private sector. The private sector even asked us to allow them to retain some expert from the Caribbean to offer some kind of advice and so on. But, Your Honor, no report has been forthcoming, and this was about 6 months ago. My friend is asking for time to consult. The truth of the matter is that this bill has been before this House since January. 5 months have elapsed. So how many months do you want to consult? You have had the bill, you have been exposed to the bill has been laid in the National Assembly 5 months ago. And we have not heard, apart from Mr. Ramjitan speaking about his engagements at cocktails, I have no doubt that it goes to a lot of those, and the banter which goes on with businessmen, I heard of no evidence of any serious and proper and mature consultation. You don't consult this type of serious business at cocktails.
On a point of order, but not a point of order, a correction. Honorable Ramjitan did also say he met with members of the private sector commission, and then after he went to cocktails.
Okay, so he met them at the cocktail,
No, he spoke to reading and
and from there they proceeded to the
No,
cocktail.
if we want to be facetious, this is my forte, so we can answer. But I'm saying on a serious note,
And I'm sure they were consuming both local and foreign beverages.
spoke about the meeting. Honorable AG, are you with me?
Yes, sir. Yes, ma'am.
He
Yes.
spoke about 2 instances,
Yes.
meeting them in a business environment, I assume, and then cocktails. So you can proceed.
The point I am making, Your Honor, is that the argument which is being advanced that there is more time, there is need for consultation, is one that is hollow simply because the bill has been here for 5 months now. And secondly, we have had consultations with the business community not in 2013 alone. This is an ongoing issue, as my honorable colleague said, for over 6 or 7 years now. So, Bank CIH, DDL, and the local players in the industry are absolutely aware of this bill. No, they are not happy. They are not happy. We are not happy either. But that is the cost of entering into treaty. My friend, Mr. Ramjitan, says that this National Assembly will not support these. But this is not from the volition of the government. This is not government-driven. This has to do with discharging our obligations under the treaty. Your Honor, I gave the Caribbean Court of Justice an undertaking. I told the Caribbean Court of Justice a draft of this bill is before the court has an exit. And I said that it has been laid in the Parliament and that there's no story, I'm telling you the truth. This is public knowledge. And that it is now in the Assembly's discretion as to whether the bill will be passed or not, because I outlined of the National Assembly. And I say all of that to explain and to illustrate that this has nothing to do with the government being a driving force. It has to do with if we want to remain as part of today's world, where treaty plays an important and a pivotal part, then we have to make a choice. It's either we...
the Principal Act.
The Principal Act here is... This is the Customs Act. Can you, Your Honor, the Customs Act is this thick. It deals with about 1 million different matters. And you have a lawyer saying repeal the Customs Act.
Repeal the principal provisions that ask for a tax.
Can I be allowed?
Mr. Ramjitan,
Is this a fish market?
Mr. Ramjitan,
And internationally, this National Assembly is a powerful institution, and indeed it is. And therefore, we are not going to comply with our obligations under treaty, under international arrangements. Then we have to make that as a position clear to the outside world. Your Honor, I am going to sit until this is quiet. This is an ongoing commentary.
Honorable members, you see, what will apply to one will have to apply to all. My position is that, as I said before, it is not a church, but it's also not a fish market. And I would expect that members are all mature enough, while no house that I know of, no assembly, no House of Representatives, as I said, as a church, people will have their crosstalk. I would expect people to regulate themselves. And to the extent that people are not disturbed. Honorable AG, I believe people will try to show me that they can regulate themselves. Please hold it.
Normally, Your Honor, when Your Honor is here, you're not here. In conclusion, Your Honor, the point I want to emphasize is that I don't think we in this assembly have much of a choice in this matter. We can withhold our support and we can deal with the consequences as a country, because we have a lawsuit there that is pending. Damages is being claimed. Passing this legislation that was not a defense, all it would have gone to do was to mitigate the damages which will flow. And I got some kind of undertaking that would have been done. But all that will happen now is that this National Assembly will flex its muscle. Guyana will flex its sovereign muscle, and Guyana will be shafted as a country under the obligation. I withdraw that word. Guyana will suffer the requisite detriment. It will suffer the requisite detriment, and it will be penalized in damages for violation of its contractual obligation. That's all. So, Your Honor, with those few remarks, I wish to say that I hope that my friends would recognize, my friends from the opposition, would recognize that we are on all the objections that they have. We share them. The sentiments that they are expressing, we can relate to them. We have been dealing with them. We have been talking with the private sector. But we simply have come to the end of the road. And it's either we stay in CARICOM or we exit CARICOM. Thank you very much.
Honorable members, I think at least when the speaker or the deputy speaker, acting speaker, is on the floor, that we expect that the house will be calm. We have 3 more speakers, and it is 4:05. We did start the assembly about half an hour late. So I am seeking